Okay. Can you hear me now?
Good afternoon, Judge Morrow. Welcome back.
Good afternoon. Thank you. How are you doing today?
Good, thank you.
Good.
Whenever we get started, we can start with position 4, Mr. Brown.
Okay. And who's representing Mr. Brown this afternoon?
Ms. McLeod. It's a conflict case, Your Honor.
Okay, thank you. Good afternoon, Ms. McLeod.
Good afternoon, Your Honor.
Mr. Brown, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Yes, thank you. You have been charged in case 22 CR 005765F with criminal trespass, family violence, and harassing communications. Is there a history? Mr. Howard, good afternoon.
What's the name?
Brown, position 4.
Anthony Brown.
I gave that one to my coworker because he had to go to felony. Hold on.
Okay, I'll wait for the history. Is this your case, Ms. Mitchell?
Yes, Your Honor.
Good afternoon. You can proceed.
Okay. Your Honor, in this case, on June 8th of 2021, the victim, Miss Chantel, spelled Shantelle, Daniels, mother to the same child as defendant, called 911 because she felt her life was in danger. That day, the defendant came to her residence, broke her Xfinity indoor camera within her residence, which was valued at $120, because he was upset since she wouldn't give him money that he asked for. The defendant also sent her texts and videos claiming he's going to have her assaulted and that he's going to damage her vehicle. Your Honor, the state's bond recommendation is going to be, as to count 1, $2,500 surety, count 2, $2,500 surety, totaling a $5,000 surety bond, no further contact with the victim, Ms. Daniels, a stay away from the incident location. Your Honor, I'm going to have to get that to you in a moment. I have the wrong address here. A 1-day anger awareness and no alcohol, drugs, and weapons. Based on the defendant's history, there's a high likelihood of him reoffending. He was convicted of battery, family violence, and criminal trespass in 2019 with the same victim, Ms. Daniels. He was also arrested on a battery, family violence this year, yesterday, that we transferred to felony. Although that was a different victim, he also has a violent history with that victim as well. So he has 2 victims that he has violent history with, both of them being females. He also has a battery conviction in 2018 as well. He has a simple battery arrest in 2018, damage to property arrest 2018, battery against pregnant female, and criminal trespass in 2016, and 2 counts of simple battery and 2 counts of criminal trespass in 2010. And that's within 16 cycles. So he does have a violent history. We also have concerns of him being a flight risk, being that he does have, he was arrested for fleeing in 2019, and due to his current open battery family violence case, we have concerns that he may flee. So with that being said, we're recommending the $5,000 surety bond. Thank you.
Thank you, Ms. Mitchell. Mr. Howard, what was the charge that he went to felony court today for?
It was, I think, battery.
Okay. Ms. McLeod?
Yes, Your Honor. My client is 33 years old. He has high school education. He is native to Atlanta. He tells me that the alleged victim and himself share a 6-year-old daughter. He is the legal father of the child. He tells me that he has had the child legitimated, and he sees her every weekend. My client is not opposed to staying away from the location since the parties do not live together and are not in a relationship, although they share a child. He's open to third-party transfer of the child so he can still continue to have parenting time with his child. He is employed, Your Honor, but doesn't have a lot of money to spend on bond. So I would ask the court to take that into consideration in setting a bond for him. Thank you, Your Honor.
Okay. For the Criminal trespass, family violence, it's going to be a $2,500 good bond. Harassing communications, a $2,500 good bond. Total of a $5,000 good bond. No further contact with Ms. Daniels. Stay away from the incident location. There can be third-party transfer of the minor child for visitation. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Brown.
Thank you, Your Honor.
I'm sorry, position 6, comms. Also, Judge, do we have a Spanish interpreter available?
Was a Spanish interpreter requested today? Do you know, Ms. Bridgewater? Or,
No, Judge, there was not one requested today.
okay, so I guess we need to request a Spanish interpreter for tomorrow's calendar. Which case needs the interpreter?
This is position number 8, Mr. Gonzalez.
Okay. So we're gonna
We can try to see if we can get one before court is over with. We're working on it.
Oh, okay. All right.
We can
Thank
get
you,
one.
Ms. Lewis.
Mhm.
All right. And this is position number 6. Is that right?
Yes, Judge, position
Okay.
6, Mr. Combs.
Thank you. Good afternoon, Mr. Combs. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Combs, you've been charged in case 22 CR 005771D with criminal trespass and damage to property. Is there a history, Mr. Howard? Is this first arrest? Okay. Ms. Mitchell?
Yes, Your Honor, in this case, the defendant damaged the property of Miss Ebony Morris, Ebony spelled Ebonee, last name Morris. We confirmed that with the victim since the name in the warrant is incorrect. But yes, the defendant damaged the property of Miss Morris by breaking the Ring camera bracket on her door and throwing it in bushes where it was unable to be located. Our victim advocate had an opportunity to speak with Ms. Morris, and she states that they got into an argument about the defendant wanting his name off the lease. And so he began threatening her and started throwing things in the home, causing damage. She then called the police, and the police came, allowing the defendant to gather his belongings. He then returned at a later time to retrieve more of his belongings, and he got upset when he couldn't get into the home. And so that's when he broke the Ring camera and threw it. The victim states that she wants no contact and a stay away and a one-time law enforcement escort so that the defendant can retrieve his belongings. Your Honor, the state's recommendation is going to be $1,000 surety, no further contact with the victim, a stay away from the incident location 6843 Glen Lake Parkway, Sandy Springs, Georgia, a one-time law enforcement escort, a one-day anger awareness, and no alcohol, drugs, and weapons. And the surety is recommended based on the nature of the allegations in this case. Nothing further, Your Honor.
Okay. Ms. Gant, good afternoon.
Good afternoon, Your Honor.
I'm going to give your client a signature bond. It's going to be $1,000 signature bond through the jail. No further contact with Ms. Morris. Stay away from the Glen Lake address. He can go back to that address on one occasion with law enforcement to retrieve any belongings he might have there, and no drugs, alcohol, or weapons while out on bond. Does that suit you?
Yes, Your Honor. Thank you.
Okay. Good luck to you, Mr. Combs.
Your Honor, will he do the anger awareness since the signature?
This is first arrest. I'm not going to require him to do that.
Okay.
All right. Who do we have next? Good luck to you, Mr. Combs.
Thank you so much.
Position 3, Mr. Britton.
Good afternoon, Mr. Britton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Mr. Britton, can you hear me? Are they frozen? Courtroom 2? Can you hear me now, Mr. Britton?
Okay, go ahead, say it again.
Good afternoon, sir. Yes, sir, I agree.
Okay, thank you. You have been charged in case 22 CR 0057773Y with simple battery. Is there a history, Mr. Howard?
22 total. Last arrest was in April 2021. Battery DV, cruelty in the third. 2019, he was convicted for battery against a female who is pregnant. He's on probation for battery DV and battery against a female who is pregnant. It's 19 CR 004-771Y. He had an 06 ag assault, possession of a firearm during the conviction. What else? I think that, yeah, everything else was in the 90s.
Okay, Ms. Mitchell? You're on mute.
My apologies.
That's fine.
Your Honor, in this case, the defendant battered the mother of his child, Miss Cheryl Nita, spelled CHERYLNITA, Walker, by choking her. Ms. Walker states that she was standing outside the incident location, which was 681 University Avenue Southwest, Atlanta, Georgia, when the defendant approached her, stating, quote, "Bitch, you still out here, you don't have any money," end quote. The defendant parked his vehicle, got out, and as he got close to her, he threw a cup of liquor at her. The defendant then forced her to the rear of the apartment complex by dragging her and choked and pulled her hair. The defendant also stated, quote, "Oh, bitch, you want to get back in the trunk, ho. I'ma kill you. Watch this. You can't be around here anymore. My folks gonna kill you. So if you die, you know who did it," end quote. Ms. Walker stated to police that she was very scared for her life. Your Honor, the state is recommending a $3,000 cash bond in this case, no further contact with the victim, a stay away from the incident location, a one-day anger awareness, and no alcohol, drugs, and weapons. Our biggest concern here is the safety for Ms. Walker. The defendant has a violent history. His battery family violence conviction in 2021 was with the same victim, Ms. Walker, where he battered her while holding her son. At that time, he received a $3,000 surety bond. And then the defendant was convicted of battery against a pregnant female and a simple battery family violence in 2021 as well. Again, this is the same victim, Miss Walker, and at that time he received a $10,000 surety bond. The defendant also has in his history aggravated assault and possession of firearm conviction as well. So with that being said, we are recommending the cash bond. He also has FTAs in his history. He has 4 from 2006. So we do have concerns of him being a flight risk, but at this time we're recommending the cash bond. Nothing further, Your Honor.
Thank you. Ms. McLeod?
Yes, Your Honor. My client is 53 years old. He is a native of Atlanta, and he has 2 young children, a 1-year-old and a 3-year-old. He denies the allegations. He does share these 2 children with the complaining witness, Your Honor. They apparently don't get along at all, and there have been some issues which have resulted in DFACS taking the children away from them temporarily. And my client says that the complaining witness has been making up stories because he's been trying to get sole custody of the children, and she's trying to prevent him from doing so. And she makes up these stories. He completely denies these allegations, Your Honor. He tells me he was supposed to start a new job today, and he wants to get out so he can do that. He's concerned about these 2 children because he's actively involved in trying to get custody for them, Your Honor. I know he does have some history, but I would ask the court to take what I have said into consideration, and that what she is saying are just allegations at this point in time. And she apparently has also been arrested for aggravated assault. So maybe some of what he says is true, that he did not do these things that she has alleged, Your Honor. Thank you.
Okay, it's going to be a $10,000 good bond, no further contact with Ms. Walker. Stay away from the 681 University address. If he needs to go back to that address, he can go back there on one occasion with law enforcement to retrieve any belongings that he might have.
They do not live together, Your Honor,
Okay.
and have not lived together.
Okay, so he's not going to need to go back there.
No, Your Honor.
There'll be third-party transfer of any minor children, and no drugs, alcohol, weapons while out on bond. Okay, good luck to you, Mr. Britton. Let's see, we do have the Madam Interpreter. Good afternoon, thank you for joining us, we appreciate it. So courtroom 2, I know that we need position number 8. Who represents Mr. Gonzalez?
It's gonna be Ms. Gant.
Okay, so however you all want to arrange it so that we can put them into a breakout room at some point, you just let me know.
Yes, can they put the breakout in courtroom 3, please?
Okay, and Mr. Gonzalez is in courtroom 3?
That is correct.
Okay, so if we can put Madam Interpreter, Ms. Gant, into courtroom 3, and courtroom 2, if we can take some cases that are not Ms. Gant's cases. I don't know if you know which ones are not hers or not.
Yes, I do, Judge.
Okay, very good. So Ms. Lewis, if we can put them into a breakout room when you get a moment.
This is gonna be position number 14, Mr. Ponder.
Okay,
You can ask her.
and let's see, who's representing Mr. Ponder this afternoon?
I do, Your Honor.
Okay, good afternoon, Ms. Kim.
Yes,
Good afternoon.
afternoon.
Good afternoon, Mr. Ponder. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Thank you, sir. You have been charged in case 22 CR 005768Y with theft of lost or mislaid property and possession and use of a drug-related objects. Is there a history, Mr. Howard?
17 total. Last arrest was in July for trespass. June, trespass, possession of drug-related objects. March, possession of drug-related objects, conviction. August 2021, trespass. September 2020, 3-count shoplifting, 1-count trespass. Another September 2020 shoplifting. One from February 2020. He pled no load of trespass and shoplifting, January 2020. You want more?
You're good. Thank you, Mr. Howard. Good afternoon, Mr. Dudley.
Good afternoon, Your Honor.
You can proceed.
Thank you, Your Honor. This incident took place on August 27th, 2022. Officer Escudero was dispatched to a larceny call at 2075 Donald Lee Hollowell Parkway Northwest. On arrival, he made contact with the victim, Miss Janique. That's going to be JANINIQUE, Miss Janique Ray, who stated that the defendant took her daughter's phone out of her vehicle and sold it. Miss Ray stated that she was inside the Family Dollar when the assistant manager told her that the defendant came inside the store with her daughter's phone and asked whose phone was it. The defendant then walked out of the store and sold the phone for cash. After talking to Miss Ray, the officer Escudero was able to identify the defendant walking in front of the Family Dollar. He approached the defendant and asked him if he had Miss Ray's phone, and he said no. He then asked if the defendant sold the phone, and the defendant admitted that he sold the phone to someone for $10. The officer arrested the defendant, and a search incident to the arrest led to him finding a used crack pipe on his person. And as such, he was charged with theft of mislaid property and possession and use of drug-related objects. As pretrial mentioned, Your Honor, the defendant has numerous theft-related arrests, which show that there's a high chance for a risk of reoffense in this case, and the state is going to recommend. No, it's not.
Okay, Mr. Ponder, we don't interrupt in this court. Your lawyer is going to have the opportunity to speak on your behalf. So
I apologize for that.
You're fine, Mr. Ponder, but let Mr. Dudley complete what he has to tell me. Okay.
Yes, ma'am.
Okay.
Yes, sir.
Thank you, Mr. Ponder. Mr. Dudley, I apologize. You can go ahead.
The state is going to recommend a total $3,000 surety bond, with the breakdown being $2,000 surety bond for the theft and $1,000 surety bond for the possession and stay away from the incident location, and no alcohol, drug, or weapons while out on bond. Nothing further from the state.
Thank you. Ms. Kim?
Yes, Your Honor, Mr. Ponder. He is 27 years old and he was born and raised here in Georgia. He has a job. He says he cleans up trashes at a smokehouse, the restaurants nearby. And his highest education level is 11th grade. He does not make a lot of money, so there's no way he's going to be able to pay for any bonds at this point. So we would like to request for a signature on bond. And yet, because of his history, if Your Honor is not inclined to give him a signature on bond, we would like to request for a maximum $1,000 surety bond, 500 each, Your Honor. Thank you.
Okay, so for the theft, it's going to be a $500 good bond. For the possession and use of drug-related, obviously $250 good bond, makes it a total of a $750 good bond. Stay away from the 2075 Donnelly Parkway address. No further contact with Ms. Ray, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Ponder.
So how much I gotta pay?
750 good bond.
So
Position 10, Mr. Hauser.
Is this position 10, you said?
Yes,
Yes.
position 10, Hauser.
I understand a breakout room has been requested for this case, Your Honor.
Okay, and who needs to be in the breakout room?
It was requested by SG Evan Dudley, so I guess him. I represent Mr. Hauser.
Yes, attorney Shelley Falk, and we also have the victim and mother here, Ms. Shelley Hauser, who would like to be in the breakout room as well.
Let me go into the breakout room with just the attorneys first, and if any witnesses are needed for further clarification, I'll bring them in a moment. So what, Ms. Falk, Mr. Dudley, Ms. McLeod, and myself, can we go into a breakout room, please?
The gentleman is smoking. I'm gonna have to stop your camera, or you're going to put the cigarette out. There is no smoking in court. This is a court setting.
Okay, let's see. Council and I have had an opportunity to discuss Mr. Hauser's case, and I see you there, Ms. Hauser. There has been a mental health evaluation requested, so that's going to be a part of the court's order that there's a mental health evaluation and treatment if necessary. It's going to be a $2,000 good bond, no further contact with Ms. Hauser. Stay away from the incident location. He can go back to that location on one occasion with law enforcement to retrieve any belongings that he might have there, and no drugs, alcohol, or weapons while out on bond. So Ms. Hauser, he'll have to get a mental health evaluation before anything moves forward regarding this. Okay. All right.
So is he going straight from there? I'm sorry, to do that?
I will sign an order regarding the mental health evaluation, and he will get that mental health evaluation, and he will remain in custody until the time that happens.
I have a question.
Let's see, Ms. McLeod.
Yes, Your Honor. I'll just hear his question, what he has to say. Mr. Hauser, is this about your bond?
Yeah, I can't. I haven't been eating well. I'm not doing well here. I was sleeping on the ground for 3 days. My leg. I gotta go see my prosthetic for my leg. It's hurting bad. I don't have any mental health problems. I didn't threaten anyone. I was just mad. My dog.
Okay, Mr. Hauser.
It's okay, Mr. Hauser. I don't think you should talk about the facts of your case.
So what is the bond? So I can't.
Your bond is $2,000. It's a good bond.
I just haven't eaten anything today. But I'm gonna eat after. I'm struggling here. I wish I could. It was a misdemeanor. I've been here 4 days.
Okay, Ms. McLeod, can you speak with your client at a later
Yes,
time?
Your Honor. Yes,
Okay.
I can.
All right, Mr. Hauser. Ms. McLeod will speak to you at a later time. Who do we have next, courtroom 2?
Position 2, Bridgers. Ms. McLeod, were you gonna call in the courtroom?
Right now, my other client is coming on.
Good afternoon, Mr. Bridgers. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Bridgers, you've been charged in case 22 CR 005764A with willful obstruction of a law enforcement officer and no insurance or no license plate or decal. Is there a history, Mr. Howard?
Second arrest, May 2021, simple battery against a person who was pregnant. Trespass. That's a pretrial bond. That's it.
Ms. Mitchell?
Yes, Your Honor, in this case, officers conducted a traffic stop on defendant after learning the vehicle had expired registration and no insurance. The defendant refused to step out of the vehicle, turned the vehicle off, and resisted arrest. The state's recommendation as to count 1 is going to be $1,000 signature, count 2, 1,000 signature, count 3, 500 signature, totaling a $2,500 signature bond, no alcohol, drugs, and weapons, and no driving without valid plates and insurance. Nothing further, Your Honor.
It seems reasonable to me, Ms. Gant.
We are unopposed. Thank you, ASG Mitchell.
Okay. Good luck to you, Mr. Bridgers.
What's the bond? What happened?
Yes, can you repeat that, please?
1,000 signature bond for the obstruction, 1,000 signature bond for the insurance, $500 signature bond for the no license plate, no drugs, alcohol, and weapons, and he has to have insurance and license plate on the vehicle to drive it.
That's through the jail, right?
Yes.
What is the total amount through the,
It's $2,500.
SOB jail? Okay.
Is there any way I can check the body footage camera?
Hold on, Mr. Bridgers. You have a right to remain silent, so you can give it a signature bond.
Please do not speak, sir. Please do not speak, Mr. Bridgers. If you would like, I'll give you a call.
Yes, ma'am.
Who do we have next?
Position 19, Thomas.
Okay, good afternoon, Mr. Thomas. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you, Mr. Thomas. You've been charged in case 22 CR 005761G with battery and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard? If you're speaking, you're on mute, Mr. Howard.
My bad. 26 total. Last arrest was 2021, probation violation. He's on probation for ag assault out of Muskogee County. It came from a 2018 arrest. 2015 probation, got a 2015 ag assault. I don't know the disposition. 2014 simple battery DV conviction out of Albany. 2012 simple battery conviction out of Albany. 2012 probation, 2010 probation, another 2010 probation. Yeah.
Okay, you're good, Mr. Howard. Thank you. Ms. Falk.
Yes, Your Honor. This happened August 27th at 8 a.m. at 731 Peachtree Street Northeast, which is the Redeemer Church. Our victim, Percy Jones, was approached by the defendant who accused him of stealing his property and telling other people about the defendant's whereabouts. At that point, the defendant pushed Mr. Jones into a utility pole and onto the ground, which caused abrasions on Mr. Jones's right shoulder and forehead. Officer Bratton then tried to detain the defendant, but the defendant pulled away and tried to flee on foot, ended up falling onto the ground and was arrested. As you have heard from pre-trial, this defendant has 24 arrest cycles. If you just look at his past 10 years of history, you'll see a number of violent offenses, including that 2015 aggravated assault unresolved charge out of Darty County, and the 2019 aggravated assault in Muskogee County, for which he's currently on probation on a 9-serve-3 sentence. And then we had, I think, some simple batteries as well as probation violations. So all in all, it just adds up to a picture of a person who is not a great risk on bond based on violent history and based on previous probation violations, and has now committed a violent offense again against this individual, Mr. Jones. We are asking for a $5,000 surety bond, which is the bond that is actually currently on this case. It was a $3,000 surety bond on the battery and a $2,000 surety bond on the obstruction. We're asking that bond remained in place given those previous cases that this defendant has accrued. We are also asking for no alcohol, drugs, or weapons, no further contact with Percy Jones, and stay away from the Redeemer Church at 731 Peachtree Street Northeast. Thank you, and nothing further from the state.
Thank you, Ms. Faulkner. Ms. McLeod?
Yes, Your Honor. My client is 46 years old. He is a native of Atlanta. He has 10th grade education. Right now, he is not really employed, does odd jobs. He tells me, Your Honor, that he's also homeless right now. He kind of goes around and stays with people here and there, but he doesn't have a set place of his own. He denies the allegations, Your Honor. He said he was at the church and he had struck up a conversation with the complaining witness, who became irate and struck him 3 times. After the complaining witness struck him 3 times, he struck him back. They got into a fight in which the complaining witness actually bit a part of his hair out, bit him in the head. So he had some injury from from what happened between them. He maintains that the complaining witness was the aggressor, Your Honor. I know that he does have significant history, but he doesn't have employment, nor does he have housing, nor does he have any money. So I would ask the court to take that into consideration in setting his bond. Thank you.
Okay. For the battery, a $3,000 good bond. For the obstruction, a $2,000 good bond, making for a total of a $5,000 good bond. Stay away from the Redeemer Church. No further contact with Mr. Jones. No drugs, alcohol, or weapons while out on bond. Ms. McLeod, I would like for you to have a social worker visit him regarding housing. And if he does not make bond, I'll see him back at the SAP calendar in 2 weeks. And if you will have someone report to me, I'll take a look at the bond again, okay?
Yes, Your Honor, thank you.
All right, good luck to you, Mr. Thomas.
Position 7, Mr.
Yes, sir.
Gilmore. Mr. Gilmore, you're done.
Good afternoon, Mr. Gilmore. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Gilmore, you've been charged in case 22 CR 005772E with battery. Is there a history, Mr. Howard?
12 total between Georgia and Mississippi. Last arrest was July, failed to appear out of Sandy Springs. July obstruction, done with it. May 2021, failed to appear. 2019 DUI. 2019 suspended license NOLO. 2014 DUI NOD. Last arrest in Mississippi, 2019 DUI. 2010 contempt of court. 2009 simple assault / ag assault DV. It doesn't have a disposition. That's it.
Ms. Mitchell?
Yes, Your Honor, in this case, the defendant battered his coworker, a fellow barber, Mr. Antonio Taylor, by getting into a physical altercation while holding an 8-inch shears within his hands. The defendant is the actual suite owner of the barbershop and told Mr. Taylor he no longer works at the establishment. While packing his things, they got into an argument. That's when defendant noticed that his equipment was missing and he went to retrieve it from Mr. Taylor's suitcase. When he got a hold of his shears from Mr. Taylor's suitcase, the two got into a tussle in the corner of the shop. Both defendant and the victim were cut with a pair of shears and were bleeding. Mr. Taylor's injuries were on his forearm and neck, while the defendant's injuries were on his thumb. Your Honor, there is a current bond of $2,500 surety in this case, and the state requests that that bond be increased to a $4,000 surety bond based on the injury and number of FTAs within the past few years, along with a no further contact with the victim, a 1-day anger awareness, and no alcohol, drugs, and weapons. Our victim advocate had an opportunity to speak to Mr. Taylor, and he stated that he no longer works there and does not want contact with the defendant. As heard from pretrial, the defendant does have 2 FTAs from this year alone, and then an FTA from last year, along with his open obstruction case, and I believe the DUI case from 2019 may also be open. So with that being said, we are recommending the $4,000 surety bond. Thank you.
Yes, Your Honor. My client is 41 years old. He has a 13-year-old child and is expecting another very soon. He denies that he was the aggressor in this incident. The facts as stated by the prosecutor are pretty much the same facts that he told me. He denies that he was the aggressor, and he was the one who actually called the police to the scene, Your Honor. My client doesn't have a lot of money to pay for a bond. And as I said, he does have a baby that is on the way, Your Honor. I'd ask the court to take these two. He also has, he tells me that he has an associate's degree in criminal justice, Your Honor. He has this new baby coming. It's a big concern of his, and he also has his 13-year-old child. So he wants to get out so he can take care of his family business. And he denies being the aggressor here. I would ask the court to take that into consideration in setting his bond. I know the prosecution has asked for the set bond to increase. I would ask the court not to increase his bond and to let the set bond that was there be the bond in place. Thank you, Your Honor.
Thank you, Ms. McLeod. Mr. Taylor, I see that you are on the line with us. This is your opportunity to address the court if you choose to. You don't have to address the court, but if you like to address the court, I need for you to raise your right hand and I'll have to swear you in. And you'll have to get to a place where you're steady. Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, we're in court. You can put your hand down, Mr. Taylor. This is a court session, so if you'll go ahead and button up your shirt for me, I'd appreciate it.
Yes, sir.
Okay, what would you like to tell the court, Mr. Taylor?
Your Honor, I was in a altercation with Mr. Gilmore when I decided to leave, Your Honor, and I found somewhere else to go. And while I was packing up my stuff, he just came at me, and I'm suffering almost life-threatening injuries. I have deep scars in my neck. Like, this man came for my life, man, and I'm a cancer survivor as well, Your Honor, and I have worked underneath chemotherapy for this man for a long time, and I don't want him out on the streets.
Okay. Thank you, Mr. Taylor. Anything further?
No, sir, Your Honor.
All right, Ms. McLeod, your client has his hand up. Would you like to instruct him?
Mr. Gilmore, don't speak.
Okay. Thank you. I'm going to leave the bond where it is, a $2,500 good bond. No further contact with Mr. Taylor. Stay away. Well, there's no stay away, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right. Good luck to you. Mr. Gilmore, you also, Mr. Taylor.
I'm sorry, Judge. I thought I was unmuted.
You're fine. Who do we have?
This is gonna be position 15 Rails.
Okay. Good afternoon, Mr. Beals. I'm Judge Eric Morrow. This is
Your
the
Honor,
state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 005769C with simple battery family violence. Is there a history, Mr. Howard?
Oh.
Okay. Mr. Dudley?
Yes, Your Honor, I just wanted to say before we got started that this was a dual arrest with position 20. I like to handle them at the same time. It's just similar.
Okay. And that's for Rachel Thurston?
Yes,
Yes,
Your
Your
Honor.
And is Miss Thurston in courtroom 3?
Yes,
Yeah.
Judge.
So why don't we do these at the same? Well, I can handle these. We can have courtroom 3 bring up Miss Thurston. So
What? Wait a minute.
First arrest for her too.
okay. And good afternoon to you, Ms. Thurston. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me, Ms. Thurston?
Yes, sir.
Okay. And do you agree to have your case heard by video?
Yes, sir.
You've been charged in case 22 CR 005762C with simple battery family violence. I'm told it's her first arrest also. All right, go ahead, Mr. Dudley. Who's representing? Is that your client, Ms. Kim?
Yes, Your Honor.
Okay, thank you. Go ahead, Mr. Dudley.
Yes, Your Honor. Ms. Thurston and Mr. Reels were arguing about her following her ex-boyfriend on social media, which escalated into a physical fight. Ms. Thurston took Mr. Reels' phone and locked herself in the bathroom. After she locked herself in the bathroom, Mr. Reels forcibly entered the bathroom and grabbed his phone from her. Ms. Thurston shoved Mr. Reels, and then he shoved her back, which caused her to fall to the floor. She got up and punched Mr. Reels in the face and left the apartment and went downstairs to her car, at which point Mr. Reels followed her, got inside her car and told her to leave. Because her stuff was inside the apartment, she decided to follow him back up into their apartment. Your Honor, there is a risk for both of these defendants to influence the other as they are in some sort of relationship here. And I'm not sure who owns the apartment, but the state would recommend at the very least no further violent contact, but a period of separation if possible to ensure that there's a sufficient cooling off period for the two. And there's going to be a $3,000 surety bond recommended and no alcohol, drugs, or weapons while out on bond. Nothing further from the state. For both.
Your Honor, my client is 23 years old. He lives here and works here in Metro Atlanta. He has a college degree. He works in the film industry, he tells me. He is the owner of the condominium at which both parties live. He tells me that he called the police just to de-escalate things. He had no idea that either of them would be arrested. That was not his intention at all. And he was shocked when they were both placed in handcuffs. He says that he's not in the least bit afraid of Miss Thurston. He wants them to continue to have contact. He wants them to continue to live together, Your Honor. And he's just really sorry that this unfortunate incident took place. I would ask the court to give my client a signature bond so that he can get out of jail. He would like no further violent contact, Your Honor, but he does want to continue having contact with Miss Thurston, for whom he has expressed that he cares a great deal. Nothing further, Your Honor.
Ms. Kim?
Yes, Your Honor. Miss Thurston is 21 years old and she was born and raised here in Georgia. And yes, it is Mr. Jordan's place, and my client wants to have a no further violent contact. And they do not have any children together, so we don't have to worry about third-party child transfer. She is working at a daycare as a substitute teacher. She has a job and she graduated from high school. She completed 1 year of college and she's planning to go back to school. We would like to request for a signature on bond since she is recommended for that, and this is their first offense. Thank you, Your Honor.
All right, so for Mr. Reels, it's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, no further violent contact with Ms. Thurston, and no drugs, alcohol, or weapons while out on bond. For Ms. Thurston, it's going to be a $3,000 signature bond through pretrial, 1 day anger awareness, no further violent contact with Mr. Reels, and no drugs, alcohol, or weapons while out on bond.
Thank you,
Thank
Your
you.
Honor.
All right, good luck to both of you.
Thank you. Position 13, O'Malley.
Good afternoon, Mr. O'Malley. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that
Judge.
Good afternoon, sir. We're conducting this by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, Mr. O'Malley, you've been charged in case 22 CR 0057666A with 2 counts of theft by shoplifting. Is there a history, Mr. Howard?
4 total. 2015 forgery in the 4th degree, dismissed. 2010, 2 counts of robbery conviction out of Gwinnett. And I think 1 out of Alabama, hold on. 2014 property crimes, criminal possession of, I guess, a forged instrument out of Alabama. That's it.
Mr. Dudley?
Yes, Your Honor. There were 2 dates of incidents, but on August 20th, 2022, Mr. Khalil Hood, Kahil, common spelling for Hood, the manager of the Family Dollar where this incident took place at 1723 Lakewood Avenue Southeast, reported that the defendant picked up 2 boxes of Tide detergent and then exited the store, passing all points of sale without paying for the items. The incident was recorded on video surveillance. Then again on August 24th, 2022, Mr. Hood reported that the defendant entered the store and stole 2 Tide detergents again. When he asked the defendant to stop, he continued to go through the door and went behind the white building across the street from the location. And again, security footage captured the incident inside the store. Your Honor, the state has a concern for a risk of reoffense in this case, as the defendant went to the same location, stole the same items within a few short days of each other. And he also has a history of theft crimes. As shown, he was convicted of robbery in 2011. And as such, the state is going to recommend that for the first count, it'll be a $1,000 surety bond. And for the second count, another $1,000 surety bond, no alcohol, drugs, or weapons while out on bond, and to stay away from the incident location.
Ms. Kim?
Yes, Your Honor. Mr. Thomas O'Malley is 44 years old, and he has been here in Georgia for the last 12 years, and he has 7 minor children that he has to support. Actually, he does not have any family members right now here in Georgia. He could not have any employment because of his disability as well. He's getting Social Security disability checks. He also needs medicines and wheelchair for hip pain as well. He has high school degree, and he also says he has a bachelor's degree, and he completed he served Army as an honorary captain from 2001 to 2004. And we would like to request for signature on bond for both charges, Your Honor. Thank you.
All right, so for the Theft by shoplifting, first charge is gonna be a $1,500 SOB through the jail. For the second charge, a $1,500 signature bond through the jail, making for a total of a $3,000 signature bond through the jail. Stay away from the family. While out on bond.
Thank you.
Good luck to you, Mr. O'Malley.
Could you
Your Honor,
repeat?
thank you, and thank you for your time, Your Honor. You have a great day. You have a great weekend. Thank you. Have a great week, sir.
You
Have
do
a
the
great
same.
weekend, Your Honor.
You do the same, sir.
Thank you, Your Honor.
Mr. Dudley?
After you said stay away from incident location.
Yes, the Family Dollar, and no further contact with Mr. Hood. Is he the owner?
Yes, well, he's the manager, store manager.
Okay, right, so if he can't go back there, so I guess he shouldn't be around Mr. Hood.
Okay.
Okay,
Thank
You
you.
said no drugs, alcohols, or weapon.
that's correct.
Thank you, Your Honor.
Position 1, Blackman.
Good afternoon, Mr. Blackman. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Blackman, you can charge in case 22 CR 005774J with simple battery family violence. Your history, Mr. Howard?
29 total. On probation, on federal probation, conspiracy to commit fraud. We got history out of the state of Maine. Hold on. 2017 kidnapping, theft by deception, criminal attempt. I think the kidnapping was dismissed. Yeah, the kidnapping was dismissed. The theft by deception was a conviction. Criminal attempt was a conviction. Last arrest in Georgia. Got 2015 marijuana possession. 2015 abandonment of dependent child. 2017 suspended license. 2013 probation violation. Underlying charges ag assault. Got an 05 battery / simple battery family violence conviction. Regular simple battery. Criminal damage, 2nd degree conviction. That's it.
Thank you. Ms. Mitchell?
Yes, Your Honor. In this case, on June 4th of 2022, the defendant battered the mother of his child, Miss Belinda, spelled Belinda, Yarbrough, spelled Yarbrough, by placing his arms around her neck. It started when the defendant came from behind Miss Yarbrough in her driveway and proceeded to choke her. When the defendant was behind her with his arm around her neck, while he continued to choke her, Miss Yarbrough grabbed her purse, which was nearby, and removed her firearm from it while still being choked. She fired 1 round into the ground near the defendant's foot without striking him. The defendant released her and fled the scene. This incident occurred in front of Miss Yarbrough's children. Your Honor, our victim advocate had an opportunity to speak with Miss Yarbrough, and she stated that the defendant showed up to her home unannounced and she was trying to run back into the house at the time he grabbed her and choked her from behind. She also states that the only reason the defendant let her go was because she grabbed her firearm and shot it, which caused the defendant to run away. She also stated that she did file a TPO against the defendant, and he was in violation of that TPO when this incident occurred. The victim filed for TPO against the defendant in June of 2021, and it was granted and was in effect from June 2021 to June 20th, 2022, so for a year. This incident occurred June 4th. Again, this is within the TPO timeframe. Your Honor, the state's bond recommendation is a $2,000 cash bond due to the violation of the TPO and possible upgrade to aggravated stalking. We're also including no further contact with the victim. And stay away from the incident location, which was 1839 Lakewood Terrace, Atlanta, Georgia. 1-day anger awareness, and no alcohol, drugs, and weapons. We do have concerns that defendant will likely reoffend. As heard from pretrial, he does have several felony convictions that he's dealing with in different states. And he's been in and out of prison as a result. As far as his Georgia history is concerned, a lot of his violent history, although they may be old, I'll just go through it because I do believe it is relevant. He has a battery and simple battery family violence conviction, simple battery conviction, damage to property conviction. This is all within 2006 and interference with custody. He also has 3 counts of aggravated assault arrests. In addition to those, we do have concerns that he's going to be a flight risk. He does have 7 FTAs in his history that we saw. So with that being said, we are recommending the $2,000 cash bond. Nothing further, Your Honor.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Jarrell Blackman is 44 years old. He has been in the Atlanta, Georgia area his entire life. He has family in the Atlanta, Georgia area, including 6 children, three of which are minors, ages 10, 15, and 17. He informs me that he does pay child support. He shares 2 of the children with Ms. Yarborough, the complaining witness. Mr. Blackman completed 10th grade. He went on to obtain a GED. He is currently employed at corporate cleaning services full-time. He has been in that position for the past 17 months. He is due today, and he's very concerned about losing his job. Your Honor, Mr. Blackman denies the allegations. In fact, he strongly denies the allegations. Basically, I would just bring to the court's attention that the defense is unaware of any TPO. And my client informs me that he was basically trying to break up with Ms. Yarborough. She did not take it well. She actually fired a gun at him, and he is adamant that he never touched her. He states that he did not know about this warrant. He learned about it because someone was driving his car, and they told him that there's a warrant for him, and he's discussed with his probation officer. His probation officer encouraged him to turn himself in, and that is exactly what he did. I do acknowledge my client's history. However, his violent convictions are very remote. There is something called redemption, and I believe that, you know, although my client has some issues with the law, they are for non-violent offenses. I am requesting on Mr. Blackman's behalf a signature bond, Your Honor, and if you determine that he is ineligible, then I would ask for a bond of no more than $1,000. We are unopposed to the stay away and the no contact orders. My client states that he does not want to have any contact with Ms. Yarborough. However, we would ask for third-party transfer so that he can continue to see his children. And that concludes my argument. Thank you, Your Honor.
And Your Honor, if I may.
Go ahead.
I'd just like to add the civil number to the TPO. It was in Fulton County, and that number is going to be 2021 CV 350193, and a 12 months family violence TPO was granted. Nothing further. Well, signed by Judge Tamika Habrowski, Houston. Nothing further on.
So noted. Thank you.
It's going to be a $3,000 good bond, no further contact with Ms. Yarborough, stay away from the Lakewood Terrace address, third-party transfer of the minor children, and no drugs, alcohol, or weapons while out on bond.
All right.
Good luck to you, Mr. Blackman.
Thank you, Your Honor.
Thank you, Your Honor.
Position 5, Poker.
Good afternoon, Mr. Coker. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do, Judge Morrow.
Thank you. Mr. Coker, you've been charged in case 22 CR 005770B with driving under the influence of alcohol less safe, willful obstruction of a law enforcement officer, and improper or erratic lane change. Is there a history, Mr. Howard?
6 total. Last arrest was 2020 DUI out of Gwinnett. It just says bond over, so it appears to still be open. 2012 misdemeanor possession of marijuana dismissed. 2006 DUI dismissed. That's it.
All right, Mitchell.
Yes, Your Honor, in this case, the defendant was seen failing to maintain his lane while driving down Medlock Bridge Road on August 28th of this year. Officers conducted a traffic stop, and when they made contact with the defendant, they immediately smelled an odor of alcohol coming from within the vehicle. The defendant's eyes were also bloodshot red. The defendant stated he had just left Bliss, which is a bar located on Medlock Bridge Road, and he didn't have much to drink. He then changed his story and said that he only drank water and Sprite. The officer conducted HGN test and found he had 6 out of 6 clues. The defendant resisted arrest when he was being detained. Your Honor, the state's recommendation in this case is going to be as to count 1, a $5,000 surety bond, count 2, 500 surety, and count 3, 500 surety, totaling a $6,000 surety bond. And no alcohol, drugs, and weapons. Our biggest concern here is the defendant's risk of reoffending. He does have the open DUI case from 2021 out of Gwinnett. And Your Honor, this is his 3rd DUI arrest within his history. So with that being said, we are recommending the $6,000 surety bond. Thank you.
Ms. Gant?
Thank you, Your Honor. Mr. Olafemi Coker is 46 years old. He has been in the Atlanta, Georgia area for 15 years. He is married and has been so since 2009. He shares 3 children with his wife, a set of twins, and they're age 8, a 15-year-old. Mr. Coker graduated from Georgia State. He has a bachelor's in finance. He is currently employed at Rogers Electrical. He has been in that position for the past year. My client strongly denies the allegations. He informs me that he did not leave a nightclub. He states that he had left a wedding reception for his family. He states that as soon as he pulled out, the cops pulled up behind him. So he does not believe that the cop had adequate opportunity to observe him changing lanes improperly. He states that he was cooperative with the police when he began the field sobriety testing. He did not quite understand what the officer wanted him to do. The officer declined to explain and deemed him uncooperative. He states that the cop, basically just kept telling him to be quiet. He became very aggressive with him. He threw him to the ground. To this day, my client still doesn't know where his wallet is. He states he didn't receive any Miranda rights. Basically, he was treated horribly, Your Honor. Now, I do acknowledge my client's history. However, I heard about 3 convictions. I did not hear about any 3 arrests for DUI. He is presumed innocent in any open cases, and Your Honor should not rely on any convictions, any arrests that have not led to convictions. I am requesting a signature bond for Mr. Coker, and if Your Honor determines that he is ineligible, then I would ask for a bond of no more than $1,750, and that would be $1,000 for the DUI, $500 for the willful obstruction, and $250 for the driving improper lane change. Thank you, Your Honor.
Okay, for the DUI, it's going to be a $1,500 good bond. For the willful obstruction, a $250 good bond. For the improper or erratic lane change, a $250 good bond, making for a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Coker.
Thank you, Your Honor.
Thank you, Your Honor.
Mara, thank you, Ms. Gant. Thank you.
You're welcome, sir.
Position 11, Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon. Yes, sir.
Thank you. Mr. Jones, you've been charged in case 22 CR 005760D with simple battery family violence. Is there a history, Mr. Howard?
23 total. Last arrest was 2018, simple battery DV. I think it was non-pros. 2016 obstruction dismissed. 2012 disorderly conduct conviction. It was amended from a possession of marijuana. He had an 04 battery / simple battery family violence conviction. Disorderly conduct. I'll leave it at that.
Okay, Mr. Dudley.
Yes, Your Honor. This incident took place on August 28th of 2022 at 6882 Fireside Lane. The victim, Rhonda Jones, attempted to call her husband, the defendant, who was out earlier in the day on the date of incident, but he did not answer her calls. When the defendant arrived home, he attempted to talk to her about why he was not answering her calls, but she told him she did not want to talk about it. The defendant then walked over and retrieved something from the dresser. Ms. Jones thought that he grabbed something that belonged to her, so she walked over to him and reached into his pocket to retrieve whatever he had picked up. When she reached into his pocket, the defendant struck her in the face with a closed fist. Ms. Jones then ran into the bathroom. The defendant followed her and struck her in the face a second time, again with a closed fist. As the defendant has been arrested for aggravated assault in 1996. I know that's far back, but I believe it's relevant to his criminal history, to violence-related offenses. He was also arrested in 1997 for simple battery family violence, again in 2003 for battery, and in 2018 for simple battery family violence. And in that instance, the victim was the same as in this case, Your Honor. Although it ended up being no pros, the defendant was let out on a $5,000 signature bond. And given his history of violent offenses, the state has concern that he will reoffend. We were able to speak with the victim, and she stated that she did not fear the defendant and that she would be okay with non-violent contact. But she also mentioned that they have had violence between the two in the past and have both been arrested for violence against each other in the past. And this gives the state concerns that this pattern could potentially escalate and become increasingly dangerous for the victim. And as such, we are going to recommend a $3,000 surety bond, no further contact with the victim, a stay away from the incident location, and no alcohol, drugs, or weapons, Your Honor.
Thank you, Mr. Dudley. Ms. Gann.
Thank you, Your Honor. Mr. Derek Jones is 50 years old. He is born and raised in Atlanta, Georgia, Your Honor. Mr. Jones has been married to his wife, the complaining witness, for 25 years. They do not share any children. My client wants to continue having contact with his wife, and I spoke to Ms. Jones. She wants to continue having contact as well. Therefore, we are opposed to any no contact and stay away provisions. Mr. Jones completed 12th grade. He and his wife own a business together. They own a business called Children Outreach, and they have been in business together for over 16 years. My client denies the allegations. He denies being the primary aggressor, Your Honor. He certainly denies striking her whatsoever. He basically agreed with the version of events until it comes down to whether or not he struck her, and he adamantly denies making any contact with his wife whatsoever. My client, yes, he does have a history. However, the violence is remote. And again, I emphasize redemption. There is such a thing. It seems like my client has turned himself around for the most part. He and his wife are gainfully employed in business together. They may have had their ups and downs, but as we heard from the state, they wish to continue forward in this relationship, Your Honor. I am requesting a signature bond for Mr. Jones. The report that I received states that he is recommended. If Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,000. And again, we are opposed to any no contact and stay away orders. Thank you, Your Honor.
And Your Honor, the state would like to also put on record, this happened fairly recently. And the reason we also recommend a no further contact is so that there was no sufficient cooling off period.
Okay, thank you both. Ms. Gann, I don't feel comfortable putting them back into the same household at the present time, but I am going to give him a $5,000 signature bond through pretrial, 1-day anger awareness, no further contact with Ms. Jones at the present time, stay away from the 6882 Fireside Lane address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there, and no drugs, alcohol, or weapons while out on bond.
Your Honor, if I may I just clarify now? I know that no contact means no contact, but they have a business together. May they have contact strictly by telephone for the business?
What type of business is it, Ms. Gann?
It is a children's outreach organization. They provide meals for children at risk.
And is it a location that's outside of the home?
Mr. Jones, may you clarify whether or not the business is outside and just about the business, nothing else?
Yes. Yes, it's, we have a restaurant where we prepare the meals at, and we, pack them up and deliver them out. We feed the, summer camp type lunch, and we also feed the promise centers and, apartment complex and stuff like that.
All right. Again, I don't feel comfortable having them in the same household at the present time. If they have a business that is outside of the home, where they both need to be, especially given the type of business it is, I will allow them to have contact at the business location, but not but not anywhere after the business. Do we have a location for that business, Ms. Gant?
I will get that from my client and put it in the chat. Well, actually, this is the best opportunity. May you place that on the record, Mr. Jones? The business, the address of the business, sir?
2091 Hilton Drive.
Did you get that, Ms. Bridgewater? Okay, all right. All right. Oh, thank you, Mr. Jones. All right, good luck to you, sir.
Thank you, sir.
Thank you, Your Honor.
Thank you, Ms. Gant.
Judge, real quick, it was 5,000 SOB through pretrial?
Yes, that's correct.
Thank you. We're completed here in courtroom 2, Judge. You can go back to courtroom 3.
Okay, thank you so much. I'll see you tomorrow.
All right, see you tomorrow, Judge. Thank you.
Thank you. All right, so do we have, this is Mr. Gonzalez?
Yes, Judge.
Okay, let's see, Madam Interpreter, if you can raise your right hand. You
Yes,
swear
sir.
affirm that you will translate from English to Spanish and from Spanish to English to the best of your ability?
I do, sir.
Okay, and good afternoon, Mr. Gonzalez. You can put your hand down, sir.
Señor, puede bajar su mano.
Mr. Gonzalez, we are conducting this hearing by video. Do you agree to have your case heard by video?
Señor, estamos conduciendo esta audiencia para usted por video cámara. ¿Está bien que continuemos de esta manera?
Sí, sí, está bien.
Yes, yes, that's fine.
You have been charged with battery family violence.
Usted tiene un cargo de golpes y lesiones, violencia familiar.
Is there a history, Is there a history, Mr. Howard?
¿Hay antecedentes?
Second arrest. 2010 simple battery DV. It was dismissed.
Hubo un cargo en el 2010 por violencia familiar, pero fue desestimado el cargo.
Okay. Mr. Dudley?
Yes, Your Honor. The defendant and the victim, Miguel Gomez Lechuga, were in a verbal argument.
El acusado y la víctima, Miguel Ángel Lechuga, estuvieron en una discusión.
The verbal argument became physical when the defendant struck Mr. Lechuga with a chair.
Y la discusión verbal se transformó en física cuando el señor le pegó con una silla.
Mr. Lechuga suffered a laceration to his neck and a cut on his left hand.
El señor Lechuga recibió un raspón en el cuello y también una lesión en la mano izquierda.
And all parties involved reside at the same residence.
Todas las partes involucradas vivían en la misma residencia.
We were able to speak with Mr. Lechuga.
Pudimos hablar con el señor Lechuga.
He is looking for another place to live with the help of the pastor.
Oh, I'm sorry, sir.
No, that's okay.
El señor está buscando otro lugar a donde mudarse.
But he has nowhere else to go as of right now.
Pero no tiene otro lugar a donde ir ahora.
He feels the defendant tried to kill him with the chair.
Él siente que el acusado quiso matarlo golpeándolo con la silla.
Given the relationship that exists between Mr. Lechuga's mom and the defendant,
Debido a la relación que existe con la madre de el señor Lechuga y el acusado,
the state has
Es
concern.
comprometida a su mamá. Y
Well,
No, no hable,
Dudley.
señor. I'm sorry.
Go ahead, Mr. Dudley.
The state has a concern that the defendant will be able to influence the witness.
La fiscalía le preocupa que pueda volver a influenciar o afectar a la víctima.
The defendant has an arrest for simple battery of family violence that was later dismissed.
Este acusado ha tenido un arresto por violencia familiar que después se desestimó.
The state recommends a $4,000 surety bond.
Se recomienda una fianza de $4,000 bajo garantía,
No further contact with the victim.
ningún contacto con la víctima,
Stay away from the incident location.
mantenerse alejado de la dirección donde ocurrió el incidente.
No alcohol, drug, or weapons while out on bond.
Queda prohibida el uso de drogas, alcohol y de armas mientras esté bajo probatorio, bajo fianza.
And the victim is on the line if it was the sound for him.
Y la víctima está en la plataforma si quiere conversar con él.
Nothing further from the state.
Nada más de la fiscalía.
Ms. Camp?
Thank you, Your Honor. Mr. Alfredo Gonzalez Meja is 57 years old.
El señor González Mejía, González Mejía, tiene 57 años.
He has been in the Atlanta, Georgia metro area for 17 years and has 2 grown children.
Ha estado en el área de Atlanta, Georgia, por 17 años y tiene 2 hijos ya grandes, adultos.
Mr. Gonzalez completed 4th grade in Mexico, and he is currently employed in landscaping.
El señor González completó hasta el 4º grado de la escuela primaria en México y trabaja en el paisajismo.
My client denies the allegations. In fact, he informs me and the warrant confirms.
Mi cliente niega lo que pasó y también lo confirma la orden de arresto o el documento de la policía.
That the complaining witness, Mr. Gomez, charged him and my client was merely defending himself.
Y el testigo, Gómez, dijo que mi cliente se estaba defendiendo.
As he was in fear of his life.
Como porque temía por su vida.
And this was also witnessed by a girlfriend, his girlfriend.
Y también esto fue testiguado por su novia.
I am requesting a signature bond on my client's behalf as he does not have any convictions for violence.
Yo pido que se le dé una fianza bajo firma, ya que no hay ninguna sentencia a su nombre por violencia familiar.
He plans to move out of the residence, therefore he plans to move from the residence and he does not want any contact with Mr. Gomez.
Él planea mudarse de esa residencia y entonces no quiere ningún tipo de contacto con el señor Gómez.
Therefore, the state's contention that he will influence the witnesses is unfounded, as my client was attacked.
Y con la declaración de la fiscalía de que mi cliente podría influenciar o ser una influencia negativa, no tiene fundamentos porque mi cliente fue atacado.
We are requesting a one-time law enforcement escort so that my client can retrieve any belongings.
Sí pedimos permiso para entrar en la residencia con una escolta de la policía para que él pueda recuperar sus pertenencias personales.
He is recommended and I'm requesting a signature bond on his behalf. And if Your Honor determines that he is not, then a bond of no more than $1,000.
Yo pido que se le otorgue una fianza bajo firma de $1,000 por él. Una bajo firma, y si no se puede otorgarle una fianza bajo firma que no sobrepase los $1,000.
Thank you. Nothing further.
Nada más. Gracias.
And I see Mr. Miguel Gomez on the line. Madam Interpreter, would you ask him if he needs an interpreter?
Señor Miguel Gómez, necesita un intérprete.
Yeah.
Yes.
Okay. Would you like to address the court, Mr. Gomez?
¿Usted quiere hablarle a este juez, señor Gómez?
Sí.
Yes.
I think that's your left hand. Can you raise your right hand for me?
¿Puede levantar su mano derecha, por favor?
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
¿Usted jura o afirma que la declaración que dará ante este tribunal será la verdad, toda la verdad y nada más que la verdad?
Sí.
I do.
You can put your hand down, sir.
Puede bajar la mano, señor.
What would you like to tell the court?
¿Qué quiere usted decirle al juez? Y hágame pausa, por favor.
Pues que se haga justicia lo que me hizo, porque la verdad, pues, casi me quería matar. Alzó la silla y me la quería zorrajar en la cabeza. Si no fue porque mi madre la alcanzó así a jalar, si no, tal vez me hubiera zorrajado la silla. Entonces yo le di
I would like to get justice for what was done. He just raised the chair like this high, and if it hadn't been for my mother who held him back, he would have cut my head. ¿Algo más? Anything else?
Pues, le voy a mostrar lo que él hizo.
I want to show you what he did.
Objection, Your Honor.
Okay, thank you. I see it.
Lo veo.
Mi mano.
Gracias.
Mi mano. Entonces, si no fuera por ella,
My
entonces sí me lo
hand.
zorrajaba en la cabeza.
If it wasn't for
silla.
my mother, he would have cut my head off.
Anything further?
¿Algo más?
Y yo pues ya lo único que hice, pues le di una patada para defenderme porque pues me había golpeado, entonces quería quitármelo.
I just kicked him because I wanted to get him off of me.
Anything else, sir?
¿Algo más, señor?
Pues la verdad pues sí tengo miedo y la verdad pues no sé qué tal si quiera hacer algo contra mí. Acabo de escuchar que había tenido algún problema también de violencia familiar, entonces no es lo mismo.
Well,
Esa
that
persona-
I'm fear that he can do something against me because I heard that he has done
Objection,
something.
I can adjust the weight. Go ahead, Madam Interpreter.
Because I don't know what he could do to me, that could cause a future problem too.
All right, thank you, sir.
Gracias, señor.
So, Ms. Gant, I take it that your client was dating Mr. Gomez's mother?
That is
right?
correct, Your Honor.
Okay. And he has no, except for a one-time escort, he has no reason to go back to the incident location?
That is correct.
All right. So it's going to be $1,000 good bond. No
Entonces-
further, go ahead, Madam Interpreter.
I'm sorry. Se otorga una fianza de $1,000.
No further contact with Mr. Gomez.
No puede tener más contacto con el señor Gómez.
Stay away from the incident location.
Manténgase alejado de la residencia donde ocurrió el incidente.
He can go back to that location on one occasion with law enforcement to retrieve any belongings.
Puede regresar solo una vez con la escolta de un policía para retirar sus pertenencias.
And no drugs, alcohol, or weapons while out on bond.
Y queda prohibido el uso de drogas, alcohol y armas mientras esté bajo fianza.
All right, good luck to you, Mr. Gomez.
Buena
Thank
suerte,
you so
señor
much.
Gómez.
And
Thank
Mr. Gonzalez and Mr. Gomez.
Thank you, Your Honor.
Y al
All
señor
right.
Gómez también. Muchas gracias.
Thank you. Who do we have next, Sergeant?
Position 12, please, Judge.
What number?
12.
12.
Good afternoon, Ms. Massey. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 005767C with battery family violence. Is there a history, Mr. Howard?
Arrest. September 2021, simple battery DV. I think it was the same victim, so I defer to you.
Okay, thank you, Mr. Dudley. Madam, I'm sorry, Madam Interpreter, thank you so much.
You're welcome,
We
sir. Have a
appreciate
good
you.
evening. You're
You have a
welcome.
good evening too. We'll see you next time.
Thank you. Yes.
I'm sorry, Mr. Dudley.
That's all right, Your Honor. This incident took place on August 28th, 2022 at 115 Georgian Manor Court in Johns Creek. The victim, Thomas McKeever, McKeever, was talking to Ms. Penland about renewing a lease as Ms. Penland rents the basement at the incident location from Mr. McKeever. While he was talking to Ms. Penland about renewing.
I'm sorry, Mr. Dudley. This is Ms. Massey. Is that going to be tied in some way?
Yes, Your Honor. She's a witness to, Ms. Penland is a
Oh, okay. All right. Okay. Thank you. I'm sorry. Go ahead.
Okay, Your Honor. And while talking to Ms. Penland about renewing a lease, the defendant became agitated. She began to throw items at Mr. McKeever and grabbed him by his shirt. She ripped his shirt and then kicked his left shin. The kick resulted in a minor laceration and bleeding to his shin. Officer Jared Montero, who was dispatched to the incident location, observed Mr. McKeever's shirt was torn on the front near the neck and a small laceration on his left shin that was bleeding. The defendant and Mr. McKeever were once involved in a romantic relationship and used to live together at the incident location. So the state has a concern that the defendant will be able to influence the witness given their prior relationship. Also, the state has a concern for a risk of reoffense as the defendant felt comfortable enough to kick Mr. McKeever in front of a witness. That gives us concerns that this isn't the first time that has happened, and is likely a chance that it won't be the last time and that behavior will continue. And as such, the state is going to recommend a $5,000 surety bond, no further contact with the victim, a stay away from the incident location, and no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
Do you have any information on the other allegations of domestic violence against the same victim, Mr. Dudley?
To the state's knowledge, I didn't see that was against the same victim.
Okay, all right, thank you. Ms. Gant?
Thank you, Your Honor. Ms. Luigi Mila Massey is 31 years old. She has been in the Atlanta, Georgia area since 2006. She has two small children, ages 10 and 12. Ms. Massey completed high school. She is currently enrolled in college. She is studying health information technology. She has a 3.8 GPA. She is also employed full-time. She manages a mental health practice. Your Honor, Ms. Massey denies the allegations regarding the case that was in 2021. That case was dismissed. Your Honor, it was the same person, Mr. McKeever. However, my client informed me that in that case, Mr. McKeever took her cell phone. She was trying to get her cell phone from him. She scratched him. It was an accident. The scratch occurred while she was trying to get her telephone from him. That case was dismissed. That is not a conviction. She is presumed innocent in this case. I am requesting a signature bond on her behalf. We are unopposed to the stay away, but would ask for a one-time law enforcement escort because she states that she has a small amount of belongings there, but she doesn't live there. Regarding this incident, she denies the allegation. She states that Mr. McKeever was upset with her because of his haircut. She states that he has that scratch or laceration on his body because he tripped. She also states that he is the one he is the one who attacked her. In fact, she states that he pushed her down the steps. She actually had to go to the hospital because of that. Her body was sore and she had scratches on her arm. So clearly my client is not the aggressor here, Your Honor. And for these reasons, I am requesting a signature bond. The report that I received states that she is eligible. We did not hear about any convictions for violence. And again, we are unopposed to the no contact and the stay away orders. Thank you.
Your Honor.
Yes, Mr. Dudley.
The state would just like to make known again its concern for reoffense, especially knowing that prior arrest for simple battery family violence was against the same victim, and there was a witness for this attack, Your Honor.
Okay. It's going to be a $3,000 signature bond through the jail. No further contact with Mr. McKeever. Stay away from the incident location. She can go back to that location with law enforcement to retrieve any belongings that she might have there, and then drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Massey.
Thank you, Your Honor.
And Your Honor, did you say it was a signature bond or a surety bond?
Signature bond through the jail.
Thank you, Your Honor.
Number 17, Judge.
I'm sorry, tell me again.
1717, Judge.
Okay, thank you.
We're still in court, ladies.
Good afternoon, Ms. Stevens. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 005742E with simple battery family violence and battery family violence. Is there a history, Mr. Howard?
The 5th arrest. History out of Alabama and Georgia. The Georgia history 2018 driving without a valid license conviction. May 2020 out of Montgomery, family offense DV. That appears to be open. 2017 failure to appear. 2015 driving with license, I guess, revoked. So I don't know if the 2020 is open, so she's not recommended.
Ms. Falk?
Yes, Your Honor. This happened yesterday at 4:45 p.m. at 5840 Roswell Road. So we haven't even had 24 hours at this point passed since the incident. The defendant, Miss Yakita Gibbons, and that's YAEQUITA Gibbons, GIBBONS, were in an argument when the defendant grabbed Miss Gibbons' hand and tried to pull off her engagement ring. That broke her pinky nail and there was bleeding around the nail. They have lived together and been in a relationship for several years. As we noted and as pretrial noted, there is a 2020 DV case from Alabama, which concerns us for two reasons. One, the risk of reoffense. It was a DV case, and we have a DV case in this situation, as well as lack of ties with the community because that offense was approximately 2 years ago out of Alabama, and the bulk of her history is out of Alabama. We have spoken to Ms. Gibbons. She has stated that she lives at a different address, so she is asking for a stay away from that address. I will put that in the chat to Ms. Bridgewater so as not to give that information on YouTube, as well as she has stated that the defendant no longer she stated she lives at a different address where the defendant no longer lives. She does state she wants no contact. She wants to stay away from her residence and a one-time law enforcement escort to retrieve her belongings. I believe she may be on Zoom, so if we can sound for her, I would appreciate that.
Okay. And
the state's recommendation is a $4,500 split bond, $2,500 surety, $2,000 signature on the simple battery, $2,500 surety on the battery, a stay away from the address, which I will put in the chat, and no further contact, as well as one-day anger awareness. And as Your Honor knows, pretrial stated he is not recommended, so we were asking that this not be converted to a signature bond.
And who needs to stay away from the Roswell Road address? Who needs to go back to the Roswell Road address? Does Ms. Gibbons need to go back there?
My client does. That is her job. Actually. That's where
Correct.
she
So
works.
Ms. Stevens currently lives at a different address, and we're asking for a stay away address from Ms. Stevens' residence, which we will put in the chat to Ms. I can put it to all parties, Ms. Bridgewater, PD Kim, and yourself, Your Honor.
Okay. I'm sorry, I'm still, Ms. Stevens needs to stay away from the address that you're gonna put in the chat. And that's the new address for Ms. Gibbons?
That is correct, Your Honor.
Okay, now does Ms. Stevens live at the Roswell Road address?
No, Your Honor, she
Okay,
works.
so I don't need to be worried about the Roswell Road address for any reason.
No,
Okay.
not to my understanding.
Okay. Ms. Kim?
Yes, Your Honor. Miss Brittany Stephens is 30 years old, and she has been here in Georgia for 2 years. And indeed, her Alabama, it's only like 2.5 hours driving from here to Alabama, where she was actually from. She has 2 jobs here in Georgia, Your Honor. She works at Smoothie, Tropical Smoothie, and also she works at this Buffalo Wing restaurant, which is 5840 Roswell Road. That's where she works. And Yaquita Gibbons came to her work and this happened. My client actually has been working there for about 1.5 years, and she graduated from high school, and also she is attending college CTU online to get a bachelor's for business administration. She completed Alabama Christian Academy, and we would like to request for signature on bond for both charges. That's it, Your Honor. Thank you. Oh, we have no objection to stay away and no further contact. They broke up. They don't need to meet anymore.
Is Ms. Gibbons on the line?
Yes, I'm here.
Okay, Ms. Gibbons, this is your opportunity to speak with the court. You do not have to address the court if you don't want to, but now is your opportunity. If you do wish to address the court, I'll need for you to activate your camera for me, and I'll have to swear you in. Do you wish to address the court?
No, sir.
Okay, thank you, Ms. Gibbons.
You're welcome.
It's going to be $1,000 good bond for each charge, making it a total of a $2,000 good bond. No further contact with Ms. Gibbons. Stay away from Ms. Gibbons' address. No drugs, alcohol, or weapons while out on bond. And was there some type of need for a one-time escort?
Yes, Your Honor.
Okay, and that one-time escort needs to go to the address that's in the chat?
Yes, I believe so.
Okay, so a one-time escort to retrieve with law enforcement to retrieve any belongings that Ms. Stevens may have at Ms. Gibbons's address. All right, good luck to you, Ms. Stevens. Thank you, Ms. Gibbons.
Thank you, Your Honor.
Position 21, Judge.
Is it Tomari? Can you pronounce your last name for me, ma'am?
Tomari.
Okay, good afternoon. I'm Judge Eric Mora. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Is that a yes?
Yes, sir.
Okay, thank you. You have been charged in case 22 CR 005763A with hit and run and duty of a driver to stop or return to the scene of an accident. Is there a history, Mr. Howard?
Second arrest. 2019 shoplifting, dismissed.
All right, Ms. Falk.
State's recommendation is a $3,000 signature bond. There is actually, to my understanding, and let me just double check, I believe there's actually only one count, which is the driving hit and run. I don't know why it's separated as though there are 2 counts, but there is only one count of driving hit and run. So we are asking for a $3,000 signature bond on that offense. And we are asking that through pretrial. And the facts as alleged are that on August 1st, 2022, the defendant, who is driving a Chevy Equinox, struck Miss Anison. I do not have a first name, just a last name, Anason. The victim and the manager were able to get the plates off the vehicle. And when the victim was shown a picture of the registered owner, the defendant, she did identify her as the person who was driving the vehicle and struck her before driving off. And just to be clear, I'm not sure if when she struck her, she struck Miss Anison herself or the vehicle. The warrant is unclear.
Okay. Do you have any objection to any of that, Ms. Kim?
No, Your Honor, except that I want to make sure that jail does not need NOD for the second charge that is on there, because I don't want her to be held in jail.
I agree with you, Ms. Kim. Ms. Bridgewater, or Ms. Lewis, can you all look and see if there are two charges?
There are not, Your Honor. I'm looking at the jail screen right now. There's one. It's separated by a semicolon, and I think when the system generated it, it looks as though it's two charges, but it is just one warrant. Double checked.
Okay, all right. Thank you, Ms. Funk.
Thank you.
So it's going to be a $3,000 signature bond through the jail. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, ma'am.
Position number 9, Judge.
Okay. Good afternoon, Ms. Hall. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 005758A with simple battery family violence. Is there a history, Mr. Howard?
Arrest. 2017 battery against person 65 years of older. That was a conviction. 2013 battery DV arrest. 2012 simple assault, felony terroristic threats. The terroristic threats was declined to prosecute. That's it.
Mr. Dudley?
Yes, Your Honor. This incident took place on August 7th, 2022 at 183 Mount Zion Road. The defendant. All right. The defendant and the victim, Ronald Brown, common spelling, had a verbal argument because he refused to drive her to the water park. The defendant became upset, charged towards him while he was standing in the living room, and slapped his phone out of his hand while he was recording the incident. Moments later, the defendant returned to where he was standing and struck him in his face.
I'm sorry, Mr. Dudley. Thank you, courtroom 3. Go ahead, Mr. Dudley.
All right. Mr. Brown showed Officer Agnor the video of the incident and a picture of the bruise over his eye that was caused by the defendant striking him. At the time of the report, Mr. Brown advised the police that he didn't call the police and report the incident because he didn't want the leasing office to find out that Ms. Hall was staying at the apartment. The defendant is pretrial. Notice she has a conviction for battery against someone age 65 or older. She had been arrested for simple assault in 2012, battery family violence in 2013. She's been arrested for battery with the third on the same victim in 2017. None of these appear to be the same victim except for the one where there's the third count on the same victim, Your Honor, which gives the state concern for a risk of reoffense, as the defendant seems to have an issue with keeping her hands to herself and likely some anger issues as well. And because of that, the state is going to recommend a $3,000 surety bond, no further contact with the victim, a stay away from the incident location, and no alcohol, drugs, or weapons.
Ms. McLeod?
Yes, Your Honor. My client is 35 years old. She's a native of Atlanta. She tells me that she works as a housekeeper for a hotel. She is the mother of 6 children, ages 16, 15, 14, 12, 9, and 5. She tells me that the alleged victim was the one who started an argument with her, and he ended up throwing a telephone in her face. And she was merely defending herself when this incident happened, Your Honor. She tells me that she has known the alleged victim for some time, because at one point he was in a relationship with her mom, and now he's apparently involved with one of her friends that she was living with. And he was upset because he didn't really want her to live there. And that is sort of the backstory behind all of this, Your Honor. She doesn't make a lot of money at what she does. It doesn't really have any money for bond. They are not family in any way, and they do not live together. At the incident location, she was living there. She has somewhere else where she can go, Your Honor, but she does need a one-time police escort to go back to the location to get her belongings. I acknowledge that my client does have some history, Your Honor, but in this circumstance, she says that the complaining witness was the aggressor, and I would ask the court to take that into consideration in setting her bond. Thank you.
All right, it's gonna be $1,000 good bond. No further contact with Mr. Brown. Stay away from the Mount Zion Road address. You can go back to that address on one occasion with law enforcement to retrieve any belonging that she may have there. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Ms. Hall.
Position 18, Judge.
Okay. Good afternoon, Ms. Stevens. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute, courtroom 3. You're on courtroom 3. Is there somebody there? Sergeant?
Yes, Your Honor.
Okay. You've been charged in case 22 CR 005743E with battery. Is there a history, Mr. Howard?
I'm gonna defer to the state. The file I have looks incomplete.
We have first offense.
Okay, that's fine.
Okay, thank you, Ms. Falk.
Yes, Your Honor. So this happened August 27th at 4 p.m. at 2875 Barnett Court Northwest. The defendant was actually lying on the ground when the officers arrived with a severe laceration to her lower leg. She stated that she came to get her belongings. She noticed her items were destroyed. And she...
Courtroom 3, would you mute for us now, please? Thank you.
She stated to police that she became angry and, in her own words, possibly threw a record player at her sister, Sierra Haynes, who is the victim in this case. A fight then took place. The defendant threw punches, resulting in swelling to Ms. Haynes' face. Ms. Haynes was also arrested for aggravated assault because Ms. Haynes then took a knife and stabbed the defendant in the leg. When the officer spoke to Ms. Haynes, our victim, she did acknowledge that the defendant threw a record player at her first and then struck her with a closed fist to the left side of her face. And according to Ms. Haynes, she was acting in self-defense. Both of them, however, were arrested. The recommendation on this case is going to be a $2,500 surety bond. Stay away from the address at 2875 Barnett Court Northwest. It's my understanding she was there to pick up the remainder of her belongings, so I don't see any reason other than for a one-time law enforcement escort for her to return back to that location. We're further asking she have no further contact with Ms. Sierra Haynes, and one-day anger awareness, no alcohol, drugs, or weapons. And I'm not sure if I put the spelling of Ms. Sierra Haynes' name on the record, but it's Sierra, Haynes spelled Haynes. Nothing further.
And Was Miss Falk, was Miss Haynes on an earlier calendar, or was she was on a felony calendar?
She's on the felony calendar
Okay.
because it's a felony aggravated assault. However, the state would say, obviously, we have some concerns about these two being around each other right now due to the allegations. And we will say, although Miss Haynes is charged with an aggravated assault, according to the stories that were given at the scene, it does seem like the defendant may have begun this, instigated this by throwing the record player at her sister and then punching her in the face.
Okay.
Your Honor, my client is 25 years old. First off, she totally denies that she started any of this. What she tells me is that she and her sister at some point lived together, but she moved out because she and her sister were not getting along. She had told her sister that she needed to come by to retrieve some of her stuff. When she went to the house, her sister was extremely aggressive with her. She left and she went up to the room that she formerly occupied to retrieve her stuff, and all she saw was glass everywhere, a lot of broken stuff. You know, her sister had destroyed her stuff. She said she had a record player there. She had the record player. She wrapped it in a quilt, you know, just to protect it because she collects vinyl records and so on. So she had the record player, and her sister was the one who pushed her while she had the record player in her hand. Her sister's boyfriend happened to be there, and he came between them. He held onto the sister and actually tried to put the sister outside. The sister, when her back was turned, she was going to her car. Her sister stabbed her. She had to be taken by ambulance, Your Honor, to the hospital. She tells me that she's having significant pain. She thinks she's had nerve damage from the stab that she has. My client is 25. She has absolutely no record. She wants to have no contact with her sister, absolutely no contact with her. You know, her only regret is that she will be away from her 4-year-old niece, who she actually cares for, but she doesn't want anything to do with her sister. She's currently in a state of shock, Your Honor, and needs medical treatment for her leg. I would ask the court to give her a signature bond so she can get out of jail, so she can get proper treatment for her stab wounds. Thank you, Your Honor.
Does she need a one-time escort?
She does, Your Honor.
Okay.
And she absolutely doesn't have any money either, because she tells me she hasn't been working for 2 months. She's looking for a job.
Right. So it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness class, no further contact with Sierra Haynes, stay away from the 2875 Barnett Court address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there, no drugs, alcohol, weapons while out on bond. All right. Good luck to you, Ms. Stevens.
Thank you, Your Honor.
And the last case on the calendar, Your Honor, position 16, I believe, is a waiver with Miss Kim. And I think she requested a breakout.
Okay.
And it's with me.
Thank you. Ms. Kim, we need a breakout for Ms. Silvers, and you've gotten a waiver, I believe, to Ms. Bridgewater.
Yes, Your Honor.
Okay, so if is there a history on position 16, Ms. Silvers? All right, courtroom 3, thank you. We appreciate you.
Thank you, Judge. I'm sorry.
Okay, no, you're fine. Is there a history, Mr. Howard?
36 total. Last arrest was in March. Criminal trespass out of the cab. Before that was February trespass, dismissed, Cab County. February trespass. December 2021 obstruction, shoplifting, felony. Another December 2021 trespass, disorderly conduct. PI. What else? 2019 misdemeanor terroristic threats, misdemeanor obstruction, conviction out of Gordon County. 2019 probation, 2018 failure to appear. 2018 probation. Let me know you had enough.
I got the point. Thank you, Mr. Howard. So Ms. Lewis, if you can put Ms. Kim, Ms. Falk. Ms. Falk, do you want anyone else to go into the breakout room?
Nope.
Okay, so if you can put the 3 of us and Ms. Bridgewater into a breakout room. Okay, just for the record, I'll put, the last case that we had was, for Mr. Silvers. He was charged with criminal trespass. It's gonna be a $1,500 good bond. Stay away from 1510, Piedmont Road, no further contact with Chad McDaniel. There's gonna be a social worker visit and no drugs, alcohol, or weapons while out on bond. Okay, Ms. Bridgewater, whenever you're ready.
Okay. Good afternoon. Once again, the reset
Your
date for
Honor.
the SA. Oh,
I do apologize for interrupting. I apologize, Ms. Bridgewater. Your Honor, regarding position 12, Derek Jones, I did reach out to his wife and she is requesting, Your Honor, that he be allowed to return to the home and that she will leave because he has a brother who is living there and he's terminally ill. So I would ask the court to, instead of a one-time law enforcement escort, please order a one-time law enforcement with escort to confirm, with police escort to confirm that Ms. Jones has vacated the property and she is on the Zoom call to verify that, Your Honor.
What position is this, Ms. Gear?
This is position 11.
11, I think it's
okay.
well, position 11.
Okay, so that's the Fireside Lane address.
Let's
And
see, Your
that's
Honor.
Rhonda Jones?
yes, it is.
Yes, Your Honor.
Yes, 6882.
So if Ms. Jones is not gonna be at the Fireside Lane address, then Mr. Jones can have a one-time escort to make sure she's not there. If she's not there, then he can reside there. If she is, he necessarily can't. Okay, is that what you were asking, Ms. Gary?
Yes, Your Honor, and I do apologize for.
No worries, that you're fine. Thank you for getting that information for us.
Your Honor, I also have something which I would like to bring to the court's attention. On position 19, Christopher Thomas, the court had said that I should get social work services for him. My understanding is, and I actually have an email on this one, that if the Public Defender's Department has a conflict, then so does their social work department because they provide the same services. That was what I was told. I have an email from one of the public defenders on this, on a previous case that I had. So it's like, I can't request a social work service for him.
Your Honor, I think there's a difference between social worker visit and MHET. So an MHET order through Your Honor is going to go through, my understanding is a different system.
Right, but this is the social work. It's a different client from the one for the MHD. This is the one with the social. So for the homeless, he's a homeless guy.
Right.
And the judge had said I should, get the social worker people involved with him, but I can't do that apparently because
I believe they can only provide general information that is available to all the public. So it would not be a more detailed visit. It would be just basic visit to hand out the brochures, if that makes sense.
Okay, and on this, Mr. Thomas, I guess I was concerned that he didn't have a place to live.
That's correct.
Yes, Your Honor, he is residentially challenged.
Right, so Ms. Kim, at least can we have someone to go give him a pamphlet?
Yes, we can do that differently.
Okay, all right, so
thank you.
I just want to give him some information to help him with his challenges. Okay, all right. Anything further, Ms. McLeod?
No, that was all.
Okay, thank you. Ms. Bridgewater.
Okay. Once again, the reset date for the SAP calendar is September the 13th. Position number 1 is going to the SAP calendar with a $3,000 good bond. Position 2 is reset further notice with a $2,500 total SOB through the jail. Position 3 is going to the SAP calendar with a $10,000 good bond. Position 4, SAP calendar with a total $5,000 good bond. Position 5 is going to the SAP calendar with a total $2,000 good bond. Position 6, reset further notice with a $1,000 SOB through the jail. Position 7 is going to the SAP calendar with a $2,500 good bond. Position 8 going to the SAP calendar with a $1,000 good bond. Position 9, SAP calendar with a $1,000 good bond. Position 10, SAP calendar with a $2,000 good bond. Position 11, reset further notice with a $5,000 SOB through pretrial. Position 12, reset further notice, a $3,000 SOB through the jail. Position 13, reset further notice with a total $3,000 SOB through the jail. Position 14, going to the SAP calendar with a total $750 good bond. Position 15, reset further notice with a $3,000 SOB through pretrial. Position 16 is going to the SAP calendar with a $1,500 good bond. Position 17 going to the SAP calendar with a $2,000 total good bond. Position 18 reset further notice with a $3,000 SOB through pretrial. Position 19 is going to the SAP calendar with a $5,000 total good bond. Position 20 reset further notice, $3,000 SOB through pretrial. And position 21 reset further notice with the $3,000 SOB through the jail. Any questions, comments, corrections, otherwise?
Okay,
No?
all right, thank you all. I appreciate it. I will see you all tomorrow.
Thank
Thank you,
Are you
Judge.
coming in, Judge?